San Francisco, a federal appeals court in San Francisco has rejected a bid by a Larkspur man to force Mars Inc. to state on its candy labels that some of the chocolate in its candy may result from child labor in East Africa. Virginia-based Mars uses chocolate in M. He claimed 3 California consumer protection laws require Mars to disclose on its labels the possible use of child or slave labor in harvesting cocoa beans in Ivory Coast. Start your day with the news you need from the Bay Area and beyond. Sign up for our new Morning Report weekday newsletter. A 3-judge panel of the 9th U.S. Circuit Court of Appeals on Monday unanimously ruled that while slave labor is clearly immoral, the consumer laws did not require disclosure on labels because the alleged labor practices do not result in a product defect or safety hazard. The court upheld a federal district judge's dismissal of the case. Circuit Judge A. Wallace Tashima wrote for the appeals panel, "We hold that the manufacturers do not have a duty to disclose the labor practices in question, even though they are reprehensible, because they are not physical defects that affect the central function of the chocolate products." Tashima also wrote, "The alleged lack of disclosure about the existence of slave labor in the supply chain is not a physical defect at all. The Department of Labor has said some children there are working under conditions of forced labor, after being kidnapped, sold by their parents to traffickers or falling victim to traffickers." But it said Hodgson could not use the state consumer laws as a vehicle for claiming violations of United Nations and International Labor Organization policies against slave and child labor. "There is not a close enough nexus between the policy at issue here, a policy against certain labor practices, and the challenged action here not placing disclosures on consumer labels," Wallace wrote. The 3 consumer protection laws Hodgson unsuccessfully sought to invoke are California Consumers Legal Remedies Act, Unfair Competition Act and False Advertising Act. He said in his lawsuit, which he sought to have certified as a class action on behalf of all consumers, that he would not have bought the chocolate or would have paid less if he knew that child or slave labor was in the supply chain. Mars Inc. said in a statement today it was pleased with the decision. "We have never condoned the use of forced labor or any human rights abuses in our supply chain and continue to combat this disturbing and complex problem working with international organizations, governments and non-governmental organizations," the statement said. But Mars believes that consumer class action litigation does not aid the concerted efforts to eradicate these practices because it offers no solution to the underlying human rights issues, the company said. A lawyer for Hodgson was not immediately available for comment. Copyright 2018 by Bay City News, Inc. Republication, rebroadcast or any other reuse without the express written consent of Bay City News, Inc. Prohibited. You might also like don't limit yourself on SIM-only plans that are only Singtel on Money Smart. Kim Lim, daughter of Tycoon Peter Lim, on being a hot premium content. Trump cancels summit with Kim scheduled for June 12 in Business Times. Expats in SG, why choose a school that has the ability? www.iss.edu.sg. Chiropractors baffled. Simple stretch relieves years. Healthhacktips.com. Sydney's sumptuous sustainable cuisine. Intercontinental hotels.